maybe your church member, you want to discuss with the pastor that, oh, this patient did this or that, that would be breach of duty of confidentiality. You can't do that. When you fail to see a patient as often as his clinical condition requires for you to be seen, failure to do what you should have done. When you make a treatment in the treatment, for example, you were to do amputation of the left limb, you made a mistake and you amputated the right limb. Failure to refer a patient appropriately, failure to obtain informed consent, failure to advise or when you give wrong advice, failure to attend promptly to a patient. You are told the patient is bleeding. You took your time, you are in a Zoom meeting, you took your time, meanwhile you're on call. You didn't make arrangement for your call to be covered. But by the time you got there, the patient had bled to death. That would be a breach of duty of care. When you make an incorrect diagnosis. And I put here in the PowerPoint, the list is certainly endless. There are other things you will know ethically is wrong. And when you do it, it can amount to breach of duty of care. Then there is a component, which I will just dismiss in a minute, criminal liability. Most issues we will have as doctors will come under civil liability. Civil liability means it's an action between you and the patient. It stops there. And that patient go to MDCN for you to be suspended or what or something like that, or goes to a court to seek for compensation. However, a criminal liability is between you and the state, between you and the government. Any person who in a manner that is so rash or negligent as to endanger human life or to be likely to cause harm to any other person, giving medical or surgical treatment to any person who has undertaken to treat is guilty of misdemeanor and is liable to imprisonment for 1 year. And where such a breach of duty of care results in the death of a patient, a medical practitioner can be liable for manslaughter. We must understand that even though most of the cases we have as doctors will come under civil litigations, if there's wanton recklessness on the part of a doctor, it can come under criminal liability. You can be sentenced to jail. We must understand. Now, when there's a problem, what happens? If I manage a patient and the patient is not happy with me, he will go to medical counsel or can go to a regular court. The options are open to the patient. You don't decide where the patient goes to. He can choose to go to medical counsel. For those that go there, usually they're not really seeking for money. That's the truth. Because medical counsel doesn't give monetary compensation. They don't have that jurisdiction. So those that go there, they are going there to the purpose of correcting the ills in society. That's a major focus. So they can punish the doctor, suspend it for 6 months. So when he comes back, we have learned his lesson. If you are looking for monetary compensation, you go to a regular court. Now, when they go to medical counsel, what are the verdicts that may be handed over? It may be simple as just admonish the patient, the doctor, that is. Number 2, it can be suspended for about 6 months, who people are already quarreling with. Because if you look at that clause, it says it can be suspended for nothing more than 6 months. People have said no. It can be extended to 2 years, 3 years, the case may be. If you say, because the doctor works hardship, when the doctor has done something that you know that this misbehavior is more than 6 months, but you don't have an opening to give 2 years in the law, I want to submit that that law is long overdue to be reviewed. Because there's nothing that gives you the power to give 1 year or 2 years, which may be more appropriate. Look at the gravity of the offense committed by the doctor, because the next option left for you is to now remove the name from the register, which may be too draconian, which is so severe. So because their hands are tied to admonishing the doctor, suspended for no more than 6 months, then the other one is outright deregistering the doctor. So that law, with utmost respect, should be reviewed. Let's quickly mention some cases. We may learn 1 or 2 things from this. Now, in this case, I hope the CMD is still here with us. Igbokwe versus UCH Ibadan. A woman delivered and had purpurar psychosis, but there was not, the hospital didn't provide adequate support to watch over her. That woman jumped from the 3rd or 4th floor and he died. Damages were awarded against UCH. Now, in the case of Olabisi and Onigbanjo, what happened here? a patient had abdominal surgery. The doctor forgot a big abdominal mop in the abdomen. In law, we say res insolocutor. The facts speaks for themselves. The doctor was suspended for forgetting that mop was suspended for 6 months. Then in India, there was a case of Mishra and the state, where the defender failed to treat a patient appropriately. Over a period of 48 hours, they have been informed that the patient was having features of septic shock, but they ignored the complaint. They didn't do blood culture and all that. They just managed the patient, in a very lackadaisical manner. The patient died. Both doctors were convicted of manslaughter for gross negligence. That's what I was saying just now. Even though most cases will come across with civil litigation, under this, for 48 hours, we were told that the patient operated will become very toxic, and you ignored it. They were convicted for manslaughter. Then in R and Becker, the accused gave overdose of diamorphine, gave 30 milligrams of ignorance. That's the thing. How can you give somebody 30 milligrams of diamorphine? You say you didn't know, and the patient died for respiratory failure. The doctor also was convicted for manslaughter. Then in Onlaye and Chama, the dental professional investigation panel, a physician failed to give prompt attention to a patient, a pregnant woman, who had features of a ruptured ectopic gestation until 36 hours after that. The tribunal found 5 physicians, including the 2 consultants, that were responsible for the death of that patient. They were found guilty of negligence. Then in Okozie, an MDCN disciplinary committee in 2001, a gynecologist had done a CS. He didn't have oxygen. He didn't have an anesthetist. He was anesthesia. Anesthetist, he was the surgeon. He didn't have oxygen when the patient needed it. The patient died. He was suspended from practice for 6 months for losing his patient because he didn't have requisite materials to do what he did. Now, what are some defenses or protection that may be available to the physician? Number one, I will dilate on 2 of them later. Number one is informed consent. Number 2, not all complications arise from negligence. Number 3, the injury could not be reasonably foreseen. Number 4, someone else caused the injury. Number 5, there was already a pre-existing injury before the patient came to meet you. Then there was what called contributory negligence. When you gave instruction to the patient and didn't follow the instruction, an injury now came up, we call that contributory negligence. Then we have the Good Samaritan's law, which I said earlier, even though the law will still be against you if you gave shabby treatment to a patient because you acted as a Good Samaritan. However, you must be careful not to rely on that too strongly. Then you can also rely on what we call the respectable minority principle. If you did something that is not probably according to standard, but you can quote Oga Eyeson, who's a renowned orthopedic surgeon. This is where he does his thing. And it's a respectable opinion in that field of orthopedics. And I did it because he did it, he has published in it, and people have respected him for what he does. If you did it according to that minority principle that is respected, then the law may excuse you. Then there are what we call statute of limitations. If you cause an injury to a patient 10 years ago, you cannot just wake up today when the thing has been overtaken by event to come and want to sue you. Like I said, I will dilate on 2. Informed consent as a defense. When a patient has given you informed consent, it offers you some protection. In law, we say volunteer non-fit injuria. When a patient is signing consent for a procedure, he already assumes a measure of risk naturally associated with that procedure. And that is why consent must be obtained by a very senior member of a team, not a house officer. I must tell this honorable audience, not a house officer. Somebody who's knowledgeable in the procedure that is being planned, who can explain the details, the nitty-gritty of that procedure to the patient, so that the patient can make an informed decision. If the patient makes an informed decision and there is a complication, you can be protected. Then number 2, you can also see this case Okonkwo and medical counsel. Okonkwo manage a patient who doesn't take blood. And the patient, you know, he went to a court of appeal, he won the case, and medical counsel wasn't happy with that verdict. He went to Supreme Court. Okonkwo didn't have difficulty. He still won medical counsel at Supreme Court. So in those two cases, Mallet and Schoolman, shows that in that case, the doctor gave blood to a Jehovah's Witness member who doesn't take blood because he was unconscious, and the doctor was indicted. Okonkwo refused to give blood, and the patient died, but Okonkwo was not indicted. So those two cases, we should be familiar with it. It can offer you a defense when you say, I did what the patient requested, and that's why the complication may have come up. I put here, you can consider taking malpractice suit insurance, because a single act of indiscretion can ruin an entire medical career. If, for example, they take you to court and they say you should pay 200 million, where will the doctor get 200 million? So you must consider taking malpractice suit insurance. Then I ask a question here. When a problem arises, what are the options available to you as a doctor? And I've heard some doctors ask this question I'm also posing to you. Can I really be sued as a physician? I can tell you this, an emphatic yes. And I say if it can happen at all, it can happen at any time. It will most likely happen when you least expect it. When a problem arises, what are the options available to you? Number one option, try to avoid litigations. Don't be arrogant and tell a patient you can go to court. Never do that. Never do that. But be honest. According to the words of Fearman in the publication in the British Medical Journal in 2009, he says the doctors can say, I'm sorry. In that research, he saw that even in the US, about 75% of cases that went to court because of the arrogant nature of the doctors that managed them. They were very arrogant. In other cases, they should have gone to court ordinarily because of the humane disposition of the doctors, they didn't go to court. So learn to be arrogant. We must learn to adopt alternate dispute resolution, learn to get the service of a lawyer early, few words as much as possible, don't talk too much. Make sure you have your lawyer before you go to court or police station rather with a policeman. Get your record straight, but don't falsify. It's very important, don't falsify. When you see that the matter is going to go to court, you go and start if certain things you didn't do before. You don't know that the patient relation may have photocopy the entire folder. What you have doctored, it will work against you adversely because you're not a witness of truth. In conclusion, ladies and gentlemen, because I'm told my time is up, lawsuits for medical negligence can be minimized or avoided by taking steps to keep patients satisfied. Adhere to policies and procedures. Develop patient-centered care. Know ways of defending against medical malpractice judgments. The over can never be overemphasized. Always document when you see a patient, put the time you saw the patient and your findings. Please don't assume, oh, the nurses saw me, the CMD even saw me enter the ward. No, sir. Document in the folder. When you are facing a trial in court, that becomes your defense. Please have a comprehensive professional liability insurance. Above all, apply the principles found in Matthew chapter 7, verse 12. In everything we do, let us treat others the way we want them to treat us. This is the panacea to avoid litigation. If you are a patient, you're an A&E, you want a doctor to attend to you promptly. And therefore, if a patient is in A&E and they call you, attend to the patient promptly. And any way you want to be managed, if you have to be lying down to go to the answer or to pay the case, how will I be managed? If you manage your own patient that way, you'll be far away from litigation. Gentlemen and ladies, I want to thank you for listening. And I want to most profusely apologize again for the internet or whatever, the Zoom that messed me up. I think a virus entered my system. Thank you, and God bless us all.
Thank you, Prof. A wonderful one by Professor Osime. I'll have to say, sir, that I envy your credentials, sir, a quantity surveyor, legal luminary, a professor of surgery, a surgical oncologist in one lifetime. Sir, that is worthy of emulation. We thank you, sir, for your time, for sharing this lovely presentation with us. I would have questions at this time, and would want people who have questions to type in the chat box or raise the virtual hand for recognition so that we can take questions. We have just 10 minutes to do that, so we'll quickly go on to other items on the agenda for today. Prof, I would want to ask something, sir, if you can hear me, while we're waiting for other participants to bring up their questions. Sir, I'm aware that the Medical and Dental Tribunal is equivalent to a high court, according to the laws of the Federal Republic. And station there, aside defending him or herself, or does the doctor need to represent himself in person, as against when he goes to court where he is entitled to legal representation? Also, sir, as you rightly said, sir, that we should treat others the way we would want to treat ourselves. For doctors that are, for whatever reason, suspended or struck out of the register or have other punishment meted out, are there ways by which those doctors can be supported? Or does it just mean that because they've been asked to leave, they are not licensed to practice? Does that mean that to become doctors and there's no form of support that can be offered to them? And thank you very much, sir, for re-emphasizing renewed ahead of time is said to be a quack. I learned so much from this lecture, sir. Thank you. It applies to all healthcare practitioners. Litigations are on the rise, most especially the more you are located in an urban center, the more liable you are. And if you're also a surgeon, you have a higher risk of being litigated. Thank you, Professor, sir.
Thank you very much for the kind words. So, do we respond now? We'll take all the questions at once.
Yes, Prof. We'll take all questions at once. We have other participants raising their hands. I would want to recognize two participants that have so far raised their hands. Dr. Tim, sir, you have the floor. Please quickly ask your questions, sir. Thank you.
Okay, thank you. Thank you very much, sir, for the presentation. It was a nice presentation. I'd like to say you were my teacher in medical school in Uniben. Thank you, sir.
Thank you very much.
My question is, there is discharge against medical advice for patients, but for a doctor, is there anything like discharge against patient's wish? Like, because of the present scenario, like the ongoing industrial action, and you have to discharge patients because you're not going to be available to offer them services. Can you be held liable if anything goes wrong because you've discharged the patient, or do they need to be properly referred to another facility because you won't be available for a strike? And then we know that MDCAN has also issued a notice of strike coming soon. As a resident, who will bear the responsibility for patients who ordinarily should be admitted under consultants? Thank you, sir.
All right, thank you very much.
Thank you, Prof. We have one more hand raised, Prof. Dabota Bowari. You have the floor.
Thank you very much for the opportunity, and thank you very much for the lecture. My name is Dabota Bowari from University of Port Harcourt Teaching Hospital. I just want to ask, because I work in the accident and emergency, and we face a lot of violence against health workers from our patient related. So does the law has any protection against us? Then my second question is, we know in Nigeria, most patients pay out of pocket. So if a patient is, for instance, is unconscious and the prescription is given, and patient does not have the money to provide the drugs, and the patient dies, can the patient is now there, can the relatives now sue the doctor? Or is there any protection against the doctor, because the doctor cannot use his or her money to go and get drugs for the patient? Thank you very much, sir. And thank you, ARD.
All right. Thank you very much.
Thank you very much, Dr. Dabota.
Okay.
One more hand is up, Prof, if you don't mind, Prof.
No, I'm fine. No, I'm very okay.
Because this is a very topical issue.
Yeah, go ahead.
Yes, sir. I would call on the immediate past president of the ARD in Igobi. And after that, we'll take just 2 more questions before our erudite professor will attend to the questions. Dr. Ndukwe, you have the floor, sir.
Yeah, thank you very much, Prof, for this wonderful presentation. It's quite mind-blowing and also an eye-opener to many of us younger colleagues of yours. But my question is this. Of recent, there are a lot of litigation issues that is being taken, that is being handled by Consumers' Rights Agency of Nigeria, rather than Nigerian Medical and Dental Association Tribunal in the area of malpractices. So I want to know the right, I want to know the stand of the law of the land. If Consumer Agency of Nigeria has the rights to try a doctor rather than Nigerian Medical and Dental Council Tribunal doing that first before the practitioner, medical practitioner will be sent to the public courts. Thank you very much, sir.
Right. Thank you very much.
Thank you, Prof. Thank you to Dr. Ndukwe. We have JP Abdul. Please unmute your mic and ask your question after identifying.
Thank you very much, Prof, for this lecture. I just have one question, sir. And mine is about concern for some of the patients who have been mismanaged for presentation.
Yeah, can you speak up a little? I'm not hearing you very well.
Please speak louder.
Yes, sir. For instance, in orthopedics, it is quite common.
Have been mismanaged by a bone setter or by some other persons who are not qualified to handle. Is there any provision where either MDCN or the managing team or the hospital can even sue some of these people who are not qualified to handle, healthcare cases and then cause significant morbidity and many times even mortalities? Thank you very much, sir.
Thank you.
Thank you very much, Dr. JP Abdul. You may please lower your hand, sir. We have Professor, sir, we still have some time for you to quickly help us.
Yes, go ahead. If there's other hand, you can ask the questions, or you want me to take them now, the answers now?
Currently, sir, none.
Okay,
Others
fine.
are appreciations on the chat
Okay, yeah,
from
I've read
other
it.
participants.
I read it.
Thank you.
I read it. All right, thank you very much for the opportunity. I want to appreciate you for the very kind words. Number one, you are very correct. The High Court and the Tribunal, or the MDCN rather, they have the same status. That is why if they decided the case, you don't go to, and you are not happy, you go to Court of Appeal. You cannot go to another High Court because they have a jurisdiction more or less. However, when I was talking, I told you that the Tribunal doesn't have jurisdiction to give you monetary compensation if you're the patient. So there is like a natural selection. There are some people, they don't need your money. They don't want you to be punished for mismanaging their person. Some people are likely going to go to medical counsel. So you'll be suspended. They also know you may better win the case. And in fact, if you follow the cases handled by medical counsel, I can say in about 80–90%, the doctors won the case. But it's a tortuous process. When they suspend you for 6 months, for example, you know the torture and all that, okay? So, or you remove your name completely from your register. So it is of the same status. The patient can decide where he goes to. You cannot tell the patient where to go to. He can choose to go to High Court. Please, Hold on. Did you read what's on my door, please? So that is number one. Then number two, representation. Yes, in the medical council, you also need a lawyer. I would advise you whether you go to regular court or medical council, you get a lawyer. You need a lawyer, medical council. You can say, I've been there, it is, and I want you can ever go there just to see what they are doing. It's the same arrangement exactly, same arrangement exactly. But just that their methods of operation is not quite acceptable to most of us. When your lawyer tries to argue some things against them, they can get angry. Which is someone you find in regular court. So if your patient goes to a regular court, I think you'll be happier if you go to a regular court. I'll be honest with you. Because when you the way they talk to doctors, the way when your lawyer tries to argue your point, the defenses available to you, I tell them that sentiments, emotions enter, and they want to get angry. Why should your lawyer talk like that? That is why most times like I said, they lose their cases when the matter goes on appeal. So that is what it is. You need a representation, because the lawyer will better be able to articulate your position. And for me, by the grace of God, I'll be available. I may not be chance to follow you to MCLM to court. I'll be available to give you some to advice. We don't pray for litigation. If you look at my paper, but if should that be, because like it may not be impossible. It's not possible to say there may not be. There are some patients. They are litigants. They are troublemakers. So you can call me. My number will be displayed on the PowerPoint I will send to your president. You can call me. If there's an issue you're not clear about, I can advise you how to go about it. Now, if your name is struck out of register, what can be done? If you follow what I was saying, the decisions of the MDC and the only three, which I think that law, our NMA, ARD, you work on it. It should be looked into. Long overdue for to be reviewed. You cannot have admonition, no more than 6 months. And the other one is abstract removal. I do not think many authorities are looking at it. It is wrong. You can say 1 year, 2 years, 3 years, 4 years, depending on the gravity of the offense committed. But for you to say, oh, this offense is more than that of 6 months, and therefore, since I don't have another window, doctor is giving outright removal from the register. That is too, it's hardship. You must sit down to think of the implication of that. When you remove a doctor's name from the register, what are you saying you should do to go and commit suicide? How will he feed his family? How will he feed, take care of his children? Maybe he has a mother, he has a father that dependent on him. I think that law, and then they should look into this, ARD can champion it. Let us see how it can be reviewed. You can have 1 year, 2 years. I tell you, it will be better for doctors that when indeed they have done something wrong. Well, I'm not saying you should condone irresponsibility, but rather than just striking up the name forever, you can say suspended for 1 year. For me, I think it's a thing ARD, MD can look into an NMA. Now, what can you do? It's your brother, be your brother's keeper. To that extent that the name is on your register, of course, you can appeal that judgment of MDCN. You go to Court of Appeal. From Court of Appeal, you can go to Supreme Court. But what you can do is to also appeal against appeal against execution of the judgment of medical counsel. But you see, to appeal against execution, it's not as smooth as it seems. There are many bottlenecks too. The court will not just grant you stay of execution because of appeal, because they also want to look at it that you're a dangerous person. The medical court you as a very dangerous fellow. So they cannot just say stay execution, because the way they will say it, you have been struck off the register, they're going to articulate their point that you are a threat to the society. And because they see as a threat, the court will not just with a wave of hand apply for it. So they also have their lawyers. A few things will be done. They will look at it. You cannot just apply, and say self-execution following week. They just say, okay, execution should be withheld for now. So you also have to understand that. So for doctors, you can support your colleague. If it's in need, you can support him. Then I also look for we can diversify. I know some doctors that are foreign exchange trading, into other things. And who knows? That doctor can go into farming, most people. So we've got to we can support them to think of what they can do while the case is going on. But the doctor should not go and be lamenting. If they remove your name from register, go to Court of Appeal, articulate your case, go to Supreme Court, and we have an example of Okonkwo. Did they accept the suspension? He said, no. Why should I be suspended? I manage a woman according to her dictates. I don't have to be suspended. And he won the case. Now, strike and duty of care. I mentioned it. You can go on strike, it's your entitlement, but there are channels. You give your notification and all that. What I was saying is that when you are going to go on strike, you don't just walk away. Maybe you already have, even for you, it's even less traumatic, really, because you are a resident. If for the consultant, but you must carry your consultant along. We are going to go on strike, you notify them. After your meeting, go and meet your consultant. Please, sir, the strike will be declared. From tomorrow, we are not coming, or from midnight, we are not coming to work. And because he's been put on notice before now, the patient will be discharged. And you are also told the patient, within that period too, you don't also admit patients arbitrarily. Because you already know that the strike is going to come out soon. So you don't admit patients anyhow. So what you do in that setting is to discharge your patients that are stable and all that, and let them go. However, somebody asks a question, what do you do with the patient? Well, you cannot, a patient is under your care. The consultant in this case cannot just walk away. You must discharge the patient, see the patient and explain to her or him that he should go to another hospital. Thank God there are many private hospitals springing up now. And I want to appeal to you, if a patient is unconscious, requires close monitoring, liaise with his family member, give the support you can give, let them go to a private hospital. You cannot just leave an unconscious patient because you're on strike, this kind of strike, and you walk away. They will see you as callous. Apart from even go to court, a patient that is injured, the relations that feel aggrieved, they can use various means to even come after the doctor. You must be careful with that also. When you give care, you are friendly, you show some empathy. They hardly, you go and look at that my slide, show empathy. They're hardly going to even be against you. Oh, they'll say this man is very kind, I was strike. He still stayed around to make sure we transfer to another place. So that's very important. The strike against medical advice. Yes, a patient can discharge against medical advice, but for the doctor, I also give an example there that you are free to withdraw your services if, for example, there's a conflict of interest. If you're not comfortable, ethical conflict. You came during war round, the woman insulted you, for no reason. And you felt bad. This woman didn't need to insult me the way he did. You let your consultant know, sir, I'm in a position to care for this patient. Even if you're a consultant, you cannot care for that patient under that setting. Because anything you do, they will misread it, even if you did it well. So that would call conflict of interest. The patient that I quarreled with you yesterday, if you did anything today, they can take it to, that is angry. A doctor had that experience. A patient, they had a quarrel because they just slight misunderstanding. And he called me, that's the correct thing to do. My younger colleague, he says, this patient insulted me because of hemorrhoid. He was bleeding badly. I said he cannot travel, but he was trying to tell me already got his ticket, he was quarreling. So he later insulted me. So I went to help your colleague. I went there and I met him. I said, what happened? He told me, I said, don't worry. The man meant well for you that you can't travel under this setting because of hemorrhoid. You are bleeding badly. So I did the hemorrhoidectomy. I took over that patient. Later, the boy bought me a pair of suits. Later, I apologized to the doctor. He knelt down to say, I'm very sorry. That is the way to make peace. The doctor did the correct thing by handing him over to me. I helped my colleague. I helped the patient by accepting the patient. It would have been wrong for me to say, no, let you suffer. No. It would have been wrong for that doctor, too, to walk away and go home because the patient insulted him. That would be wrong process. But violence in A&E, in Port Harcourt, I gave, if you read, anybody will send a slide to you. You are entitled to protection, provided you are doing your work according to the standard of operation. Let me give you an example. In UBTH, who was a nurse though? In UBTH, NEPA took light. And the nurse, just a way to make a point, in that, then I was the DC man of the hospital. In that location, they have at least 6 rechargeable lamps. A patient's temperature was almost 1540. They are waiting for the son to go get paracetamol. I think that some people were strike or so, family wasn't working, whatever. Then the patient entered, the son entered the rain to go and get the PCM. He brought it. Just before he came in, the NEPA took light. Then the generator didn't come on, an emergency. But they had a rechargeable lamp. The nurse on duty refused to give the IM paracetamol, IV paracetamol, to bring down the temperature. The woman died. The children beat up the woman. I said, come on, eat the cups of this patient. Then I asked the doctor this question. That nurse, does it deserve to be protected by the hospital? Yes or no? Is the doctor hearing me?
Yes, sir.
So that nurse, should that not be protected by the hospital? In your own judgment, be honest.
In my own honest, if there is enough light that will be provided for by the rechargeable lamp, which will provide enough vision to give that IM drug.
So I give you something. So a woman who was very ill. So
yes, sir.
A situation too where a doctor is on call, they call you, somebody is bleeding, maybe an only child. I give you a scenario. An only child having a ruptured spleen is bleeding away. Where the SRO on call is general surgery. You went for a friend's party to 30 kilometers from the hospital. Before you got back to A&E, without making adequate arrangement for a cover, the patient bled to death. If the relation beat up that SRO, are you saying the hospital should protect the SRO?
No, sir.
I humbly submit that SRO is not, cannot be protected. So, but when you are doing your duties in accordance with the principles of operation, you are entitled to be protected. We must get that right. Let us follow that, please. We cannot, if that comes to equity, you must come with a clean hand. And I put it there, they will give you the slide. Failure to attend promptly to a patient. They cannot call you to come attend to an asthmatic, for example, and it takes you an hour to attend to the asthmatic. Just before you arrive, the patient died. When there's evidence to show that you're not busy doing anything in the hospital, maybe you're just chatting, you're in the meeting, you're just chatting in the meeting, you're waiting to make your point at an OGM before you leave, before you got the patient died. So let's be careful. All right? Then, for patients that don't have money, I will advise you, some of you, when you finish, you may have private hospitals. What I do in my private hospital, for those that don't have money, I will tell you to stay out of trouble. I do defensive practice. When they come, you study them. They don't have money. I had a case, perforated DU. He didn't have money for, so we'll take card. Was in shock, called the extremity and all that. I quickly put on normal saline, gave some hydrocort. I said, let's package this patient to teaching hospital. When we are going to the vehicle, then my nurse said, sir, they not pay for card. I told the nurse, you have sense. This woman is already in shock. She was going to die. Do you know, I followed them to the hospital, to the teaching hospital, to assist them with the logistics. Because they live on my street. To assist them with logistics. I knew it was a bad case. I made them understand I don't have the capacity to care for this woman here because I saw them struggling to open the folder. You must be. I assisted them in the hospital, but later that night, the woman died. Do you know when I came following day, they remain grateful to me, nearly down all that. I do that frequently. Give the minimum you can do. Put up one bottle of normal saline will not kill you. Someone is bleeding, apply dressing, put on normal saline, and go to the teaching hospital. Because if you refuse to give care and the patient dies, there can be issues. The teaching hospital, that shouldn't really happen. Like Bobby is so set up primarily for gain. We must say that. If a patient is genuinely helpless, and if the CMD is hearing me, you can give care because the teaching hospital has the capacity to look after this. They can make a statement. Some bodies can come and write up some bills for teaching hospitals. So you cannot ignore a patient and all that. So that way I will answer that. Then mismanaged cases. Yeah, that's the last question. I'm rounding up. Mismanaged cases, you are very correct, but it should not be your place. In law, we say you are advised to stay out of the arena of conflict. It shouldn't be my position to now start telling a patient to go to court. No. You know, and the traditional bond setters, they are under a different body. You cannot overrule what they are doing. So, but the medical NMA, ARD, or NAD, or whatever, can make law, can send position to the National Assembly, so send a bill that can regulate their practice, for example. It's only then that can happen. Otherwise, if they know that we're mismanaged, then of course, the patient may be the one to do that, not you at all. And you must always stay out of trouble. Never get yourself into arena of conflict to the extent you don't want to tell the patient, oh, this one mismanaged you, go to court. Even if your colleague mismanaged the patient, also try to be careful the way you divulge that information, because the times we are in are very evil. You must be extremely careful. Thank you very much. I hope I've attended to the question.
We are indeed very honored to have you today in our midst. You have really opened up a lot of discussions, and we hope that all our participants here are better off with this presentation and robust discussion. And we continue, I think additionally, sir, whenever we see some of our colleagues overwhelmed at work, we all should try and help one another so as to help reduce the workload. It's a pleasure to have you again, Professor Osime. We'll share your slides with other participants they may so request. Our email has been shared on the platform. Professor,
I'll send it to you.
We're happy to have you, sir. Thank you, sir.
Thank you so much. God bless you. I appreciate
Thank you so much, sir. Yes, sir. Yes, sir. Permit me to quickly recognize the head of the Emergency Medical Services in our midst. Dr. Ranti Babalola is a consultant orthopedic surgeon. You're welcome, sir. In our midst also is a past secretary of the NAD and also the founder of the Doctors Timeout Family, as Dr. Anthony Ude. We have quite a number of potards, president of the Association of ARD, Dr. Kusoro from OUTHC in Ile-Ife, Great Ife, from the Federal Neuropsychiatric Hospital in Yaba, Dr. Lade Jare, the potard of FMC Owerri, Dr. Obi Ugo-Jude. We also have a president of the Association of the ARD, FMC Ebute Meta, Dr. Kemi Windapo, a potard, FMC Abeokuta, Dr. Adebiyi, the secretary of the ARD, Abubakar Tafawa Balewa University Teaching Hospital, Dr. Awal Muhammad, and also the North Central Caucus leader, Dr. Dukodri Idrisu. These are just some of our colleagues, also from Jude, from University College Hospital Ibadan. We all recognize you. Distinguished ladies and gentlemen, we'll move on to the next agenda for today, which is the citation for Barrister La-olu Osanyin. That will be taken by Dr. Sekina Shitu. Dr. Sekina Shitu, over to you, ma'am.
Okay, thank you. Standing on existing protocol, I'll be taking the citation of Mr. La-olu Osanyin. He's an internationally renowned medical legal consultant and the vice president of the World Association of Medical Law. He is currently the first and only African on the board of governors of the World Association for Medical Law, which is the medical legal advisory council to the World Health Organization and International Criminal Courts. He is also a member of the American College of Legal Medicine. He serves on the board of the Nigerian National Health Research Ethics Committee, and until recently, he also served on the Ethics Committee of the American College of Legal Medicine. Barrister Osanyin currently serves as the Chair Committee on Medicine and the Law of the Nigerian Bar Association section on legal practice. He is the founder and convener of the Nigerian Medical Law Summit. He is also the Chief Counsel of First Counsel Solicitors, a medical legal consultancy firm. So once again, please do join me to welcome Barrister La-olu Osanyin. Thank you.
Thank you for having me. I must, first of all, say that I find it a bit challenging speaking after the last speaker, whom I am totally in awe of. I guess, and as a matter of fact, I must confess that I hope you can hear me though.
Loud and
I
clear.
hope you can hear me. All right, fantastic. Yes. So
Yes, we can.
thank you. So thank you for having me. It's quite a daunting task speaking after the professor. So as a matter of fact, listening to him was a good idea because I had to ultimately change my slides. I had to change the entire topic I planned to talk about. Honestly speaking, because we would probably be repeating each other. I would have been repeating what he just spoke about. So I decided to pressure of changing the topic I've been talking about today. So I decided to talk on medical legal pitfalls in medical practice, solely because we live in a litigious environment. For example, I spent the entire, throughout last week, I was at medical tribunal. We had cases of doctors who had been petitioned against the medical tribunal. The entire week there, and we didn't conclude our matters. The reality on ground is that malpractice is an industry in Nigeria now. Patients are suing. The tragedy of the situation here is that health workers are aware. Most majority of health workers are not aware of the legal responsibilities or legal rights, as a matter of fact. So the relationship is a bit toxic. I always say that best person to sue nowadays in Nigeria is the Nigerian health worker, particularly the doctor. And I'll give various reasons. I decided to talk on medical legal. Why is it easy to sue a Nigerian doctor? So I'll just have to clarify certain misconceptions, things that you people do on a regular basis that actually leads you to court. I run in Lagos here, and we are probably one of the few in the country that resume virtually every day in a hospital, even for the fact that it was an online, a virtual program. I would probably have been at a facility where you people would have been right now. We resume virtually in a hospital every day, either defending doctors or suing, as the case, depending on who commissions us. But we found that there are certain things that we find in common in the practice of medical law in Nigeria. Essentially, it's centered around the ignorance of the health worker. So I'll try and bring out some of the issues that leads them into the courtroom. There's a consistent increase in litigation. Last time we checked, now we have 200% increase in lawsuits against health workers. 200% increase since 2000 and now. So it's quite an alarming rate. So how do you protect your practice from avoidable liability? The first thing I noticed, working for several hospitals and several doctors in Nigeria, is lack of what we call credentialization. Credentialization is a concept where before you employ or you recruit an individual into your organization, particularly a medical practitioner, it's imperative for the management of the facilities to do a background check on this health worker. Has he been to medical tribunal before? Has he been suspended before? Does he have pending cases? I'll give you an example. The doctor still walked into my office here yesterday. Legal services, and I asked her what she wanted, and she said, well, that she wants to travel to another country, I think to the UK, and the GMC is asking her for clearance from MCLM, but she has a pending case at MCLM, so she can't actually, transmit. How many of us have done that? How many people have recruited staff knowing fully well that they have baggages on? And I'll give you a true life example. I work for one of the biggest hospitals in Lagos here. who actually put a doctor on their website. That UK trained doctor, he's had 15 years working as head of blah, 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 in somewhere in the United Kingdom. Posted on their website, and the patient decides to sue, and the patient decides to investigate the status of this doctor. Find out that doctor has since been, that doctor's name has since been struck off the register of doctors at the GMC. But yet the Nigerian hospital they had recruited them and employed him here without even knowing that the person they have employed had pending cases, or in fact was no longer licensed to practice in the UK. That's why you can't practice here, but it's important for you to know, because you have put an organization out as having a doctor who can practice. I also have a case I had here recently, where a doctor who had pending cases at medical tribunal, came from hospital to the one, from one hospital to another, are committing the same offenses. So it's important as employers, it's important as senior management staff of facilities to do what we call credentialization, do a background check on your staff before you recruit. Another area where you have problem, is with additional qualification. I was at medical tribunal last week, and 3 of my clients were charged, amongst other things, for not registering the additional qualifications at MCLM. And the law says that every doctor who has acquired specialist qualification is required by law to be registered with the council as a specialist before he can practice and recognized as a specialist. That's also the case as well. One of the doctors had done, I think West African, but done part 1 and not done part 2, blah, blah, blah. He doesn't have additional qualification. Unfortunately, he put himself out as a specialist. I'm just trying to give you guys the low-hanging fruits, issues that would ordinarily lead you into the courtroom. The Prof had extensively dissected and had discussed the issue of negligence. But there are other instances as well. Because what we do when we sue you people is that we are throwing a net into the lagoon, looking for as many things as possible that we can use. So I will put negligence there, I will put misconduct, I will put a lack of additional qualification, I'll put as much as I can there. At least one of them will convict. Another place where you have problems is treating emergency or gunshot victims. The law says that you should not refuse a person in need of emergency treatment for any reason whatsoever. And the law also provides fine and imprisonment, or option of both. Should you refuse? So the question is, they rush the patient to your facility, what do you do? Some hospitals just not treat at all. I like what the Prof said when he talked about the need, but even if it's the under normal line you use, do something and refer such a patient to multidisciplinary center where the patient can be better treated. But refusing to treat the patient is a violation of the law. So I always advise that what you do in such instances is just stabilize and refer as much as you can. The question people always ask, who is going to pay for it? Just stabilize and refer, essentially. There's also emergency admission and the 4 and 12-year rule, where the law says that every emergency admission should be seen by a doctor on call immediately, certainly not later than 4 hours after admission, appropriate by a consultant within 12 hours. It's in the code. So you find a lot of patients who are just eagerly waiting for you. They've been in your hospital for 4 hours and recording, and they're timing you. At the expiration of 4 hours, they can travel to substantiate it against you. Then informed consent. I always very amusing when people inform consent with the need for consent form. Totally different issues. The law expects you to let the patient sign a consent, but the law also expects you to discuss with the patient what you're about to do with the patient, benefits, the risk, the cost, the side effects. You should also have it in mind that the patient can refuse medical treatment, even if it's for his own good. Most importantly, the law expects you to discuss with the patient in a language in which the patient understands. So when you tell a patient who is a vulcanizer that the carcinoma has metastasized and his axial volume is low, and you have to conduct the colostomy operation for him tomorrow morning. In effect, communicate to that patient in the language the patient understands. So the law expects you to discuss the benefits, the risks, options in a language that the patient understands. And we find this virtually, absent in most instances. And it's also important that doctors, that surgeons should record in their case note that they had a session with the patient. It's imperative for you to state in your case note that I had a session with the patient where I discussed the options, risk involved, benefits, and the patient understood. Because in medical law, we say that if it is not written, it did not happen. So I say it again, if it is not written, it did not happen. So if you did not record that you had a session with the patient, you don't totally assume that you did not. So patients are now beginning to sue practitioners when they say, for example, he or she did not tell me the side effects of the procedure I was going to have. They did not tell me that I will lose my sexual libido. They did not tell me that my lifestyle will change. And I will say this before I move on. It is the patient that most benevolent to that will sue you. So you need to understand that the fact that patients are quite fickle-minded, and patients can sue for whatever reason, particularly when they see the bill. Regardless of the outcome of the procedure, they can institute an action against you. So I give this as a medical legal nugget. In medical law, from the patient's perspective, when complications occur, the surgeon's reminder that it was discussed before the surgery is a valid explanation. However, when the complication occurs without prior discussion, the same explanation becomes an excuse. So there is need. I don't know for a certain that facilities and others, they usually leave the burden of informed consent to the nurses. No, not supposed to be so. Informed consent would actually be given by the surgeon, telling the patient the benefits, risk involved, options available in a language that the patient understands. I hope that is clear. Now, when I say that doctors are the easiest persons we sue, is because essentially they're very practical people. It's a Nigerian doctor that will go leave home every day, see several patients, and not make recordings of them. We can do an experiment here. Maybe the management of the facilities, for this facility, should just do a random check, pick a random case file, and say that if this patient sues us today, will we be exonerated? Because the bottom line is that quick documentation just essentially helps you to refresh your memory about what treatment you give the patient. You cannot definitely remember the patient you saw 3 years ago, Easter Monday, but that patient can come to your office tomorrow with a lawsuit that you treated him or her. The only way in which you can remember is what? Is documentation, and that is where we find out that the majority of health workers are really laxing. To the extent that now, we even use nurses' notes as well to buffer the lapses of the case notes. But even at that as well, we find really shoddy input by doctors. So the doctors that are easily sued are usually the ones that are very poor in record keeping. Now, blood transfusion as well. That's also another angle where patients usually sue, where we find out that the doctors at times become quite judgmental. Where we find at times that doctors, waiting for the patient to suffer. Maybe when he suffers, he will come to his senses and make up his mind. We find out that, so you must also respect the fact that the patient has a right not to take blood, even if the future will lead to his death. That has been settled by the Supreme Court in the Concourse case that the earlier speaker spoke about. In such instances, do not hesitate to just refer. Well, we also found out again when lapses occur is with instances of poor follow-up. I'm having a case on my desk at the moment of a lady who came to a big hospital in Lagos here, did a biopsy, and the result never got to her until 2 years later when she now has full-blown breast cancer. So it's important that follow-up care is essentially important, and we find out that that's another angle now where doctors are being sued extensively. The concept of the responsible medical officer is the concept that talks about the fact the consultant will always be consultant, or the most senior official on duty will always be responsible for errors or omissions of the subordinates. So in that instance, is where consultant, I did not touch the patient, but who was a consultant in charge? You own the patient. You cannot absolve yourself from responsibility. The thinking of the law is that you are the one who is responsible. It's also the same, same principle with vicarious liability, where the master will always be responsible for the errors of the subordinates. It's also very important for doctors to keep abreast with developments and knowledge in practice. We find out a lot of times as well. So for example, I was part of those that wrote the ethical guidelines for cosmetic procedures in Lagos State. I was one of those that wrote ethical guidelines for technology in Lagos State. So you cannot be practicing in Lagos, for example, now where there are ethical guidelines in some areas, aspects of medicine, and you cannot be aware of it. The law imposes a duty on your part to be able to keep up with developments in medical practice. Another area where we are soon going to start getting problems with litigation is with telemedicine, where people are engaging without physical interaction. At the American College of Legal Medicine, we also able to discuss the legal implication of what we call telementoring. That, for example, is where the consultant is probably in California and is instructing a Nigerian doctor on an operation. The question is, can a doctor who is in California, is he licensed to practice medicine in Lagos? So with telemedicine as well, where you are on the phone with a doctor whom you do not know where he's from, but he's sitting you in Nigeria, located in Nigeria. So is that Indian licensed to practice telemedicine in Nigeria? Does he have the legal license to practice in Nigeria? Secondly, is the fact that if you look at the Code of Medical Ethics, it poses a duty on you to see, touch, and feel the patient first before you can engage in telemedicine. I always advise that first interaction with patient is key. First interaction with patient should be physical interaction. Telemedicine can be for follow-up. But we also find out again that with telemedicine again is hacking, possibility of you being hacked and all, so there are going to be certain legal issues that will be arising from telemedicine in the near future. I've been told by medical experts, for example, that having peptic ulcer can give you the same signs or symptoms as having a heart attack. So how do you, for example, effectively give consultation? Now, do not forget, and I like what the earlier speaker talked about, people at the medical council, at tribunal, and lack of they are sentimental, which is what the judge isn't, so all you need is one person's opinion there to be stoic, and you find out that everybody is thinking along that way. So there are lots of work to be done, there are lots of interactions, there are lots of reforms to be done in law. So if you look at disposition of medical tribunal, medical council as we speak today, I kid you not, look at their disposition. If you look at the code, their disposition and telemedicine, you will find out that it is safer for you to see a patient first physically than follow up, then use telemedicine as a follow-up care. The disposition of medical council as it is today will indict you if you have your first interaction with the patient, via telemedicine. We're also not supposed to, we also find doctors making declarative statements. We have certain cases we are handling now where doctors are talking on television and making declarative statements. Such statements can only be made when you are having such professional forums such as this. So there are cases where a doctor says on television, oh yes, a 65-year-old woman can deliver a healthy child without complications. Such declarative statements can only be made freely, when you're in the midst of your professional colleagues, when you're having scientific conferences and things like that. But there you have to be very circumspect, not making them on the pages of the newspaper or on television. We found case doctors being indicted in regard. clear the air on allegations. We also find out as well that at times, okay, I'm handling a case now that went viral a few months ago, and the patient can talk and make press conferences, and but we, the defense and working for the doctor, you are not allowed really to come out and speak much about the case, because the case is likely to be in court. You are not supposed to talk about it because the possibility of you divulging information is very high. So you have to be very circumspect in that. But when they call you a quack, the law allows you to clear the air that I'm not a quack, I'm a licensed medical practitioner. Now, where doctors also have problems is when you address letters to whom it may concern. We have cases at medical tribunal as I speak now, yes, where a doctor wrote a medical report to whom it may concern. You are always advised to write medical reports to identifiable individuals. You cannot write patient information, patient private confidential information to whom it may concern. It must concern an identifiable individual. So I'll advise, these are ways, these are things that you tender at medical counsel, for example, that they see and they prefer charges against doctors. So I'll advise that, you take this, advertising too is another issue. You find out that disposition of medical counsel and the code again kind of whittles advertising to any kind of popularity or any kind of prominence you may have. You have to be quite circumspect as well with how you go about. But the law allows you, in all honesty, to do what? Public enlightenment. The law allows you to talk about, class certificate, you can talk about endometriosis, you can talk about whatever area of law, area of medicine you're practicing in, as long as you center it around public enlightenment. Right now, I'll also talk about the right of the health worker. Yes, you're empowered by law to sue. You can actually sue your patient. If your patient is owing you money, the patient assaults you, you actually have a right to sue. A lot of people do not know that, but the law empowers you, to sue, a patient who owes you money or who physically or verbally assaults you. Where you also have problem is when doctors undercut themselves. So a patient who deliberately undercuts colleagues within the locality of his practice in the fees he charges corporate bodies, or by reducing other colleagues' patients by consistently charging ridiculous fees, whether to corporate or private persons, or behaving in a disgraceful manner, an issue of fees to be paid, shall be deemed to have conducted himself infamously in professional respect. So if everybody is charging, for example, 500,000 naira for a particular procedure, then you begin to charge 170,000. And you find out that you are now poaching their patients from other hospitals. You can actually be found for professional, infamous conduct, in professional respect. Fee splitting. These are instances where doctors collude with diagnostic centers to collect commissions. If a patient can prove that it is unethical, the law has proved that there's a consideration that you have put other financial considerations above the interest of the patient. Limitations of clinics. A lot of doctors also have problems with this, who register facilities as clinics and begin to do invasive procedures. Clinics are not supposed to have, they're not supposed to be for invasive procedures. They are basically outpatient facilities. So we now have instances where doctors could do cesarean sessions, and other procedures that are invasive. The facility is registered as clinics. I know the first thing most people will say, well, what about Mayo Clinic in America? Well, the law in Nigeria says that clinics are essentially outpatient facilities, and we shouldn't have invasive procedures in clinics. Occupational health. Company health workers face unique challenges arising out of their dual loyalty to patients and employers. So can the company physician strive to uphold traditional notions of patient confidentiality, while at the same time, simultaneously advancing the employer's, goals of productivity? So we find out that at times when you work for a hospital, for a company, and you're a doctor to a company, and you're a doctor to the staff of the company, you find health workers in 8 instances of conflict there. So there's need to balance it. Therefore, even though it is reasonable to expect that the report will go to management on patient management, it will be usual for the report to contain advice in terms of functional abilities of the individual and prediction of time skills for recovery, for return to work or normal duties. The report will not normally contain any medical details of the condition or their treatment. So for example, what I'm trying to say here is that if essentially they are a doctor to a company that has workers whom you see, what the law expects you to do is just to tell the company about that worker's fitness to continue to work there. You're not expected to talk about the worker's HIV status or the worker's wife's pregnancy issue and all that, So there's the level of discretion to be issued in that regard. As I wrap up, I will just give you tips to avoid for avoiding liability. First of all, is make a impression, establish your baseline, that is, know your patient. I tell you for free, patients usually, the cases I am handling, most of the lawsuits that occur from Lagos Island to Lekki Aja axis. We also have instances of cases around Okota and Festac, a few in Surulere. You don't find in Ajangbadi and all. So when you find that you know your location, by the time you know your location, you know your patients. Most of the people that sue are diaspora persons, people who have come from abroad, or those who are just willing to make money. So know your patients. Be aware of your strengths and weaknesses. Delegate care legally and carefully. Administer drugs carefully. Maintain rapport with patients. Think before you speak. Document care accurately. Document use of restraints. Comply with laws about advanced directives. Advanced directives are instances, for example, where you say, do not resuscitate, or I do not take blood, or things like that. So you must comply with the laws about that. Adapt your facilities policies, keep up to date in changes in policies, and provide a safe environment. So Nigerian patients, in conclusion, have become aware of their rights and they are willing to assert these rights. The Nigerian patients can easily become litigious, particularly with prospects of monetary compensation. The reality is that a whirlwind of petitions and litigations against doctors is already existing in Nigeria. Consultants, supervising doctors, hospital administrators, etc. will always be called to question when allegations of negligence is made against any of their subordinates. So I thank you for listening. I'm going to take a few questions.
Thank you very much, Barrister La-olu. It's been a wonderful presentation. I think the title of this presentation is simply put, how not to get yourself into trouble. It's applicable to both doctors, nurses, physiotherapists, all healthcare workers. And it's been a very enlightening one. Thank you very much, sir. I personally learned in the area of to whom it may concern, so thank you for shedding light on that. Is there a possibility, sir, for us to get these laws, these documents, and also your presentation, sir? Would also like to study it individually so that we can always keep ourselves abreast. On the issue of documenting restraints, I didn't quite get that, sir. Does that mean if we need to restrain an aggressive or a psychiatric patient, is that the area? And then, sir, most of the time I notice that the consent forms are already like pro formas. They're already pre-formed. Is there a way, because especially surgical interventions, they're quite diverse. Is there a way that consent forms could be particularly tailored towards the procedure that is to be done? That's as much as I have, sir. Questions can be put in the chat box, please. We have 10 minutes to address this. Please type your questions, or by show of the virtual hand, we will identify. Dr. T, you have the floor. Sorry, Barrister, sir, do you wish to take all the questions at once or?
Yes, let me take all the questions at once, please.
Okay, sir. Dr. Tim, you have the floor, sir. Thank you.
Thank you very much, sir, for the presentation. My question is with regards to the 4 hours and 12 hours required for the doctor on call and the consultants to see the patient. In facilities where you are short-staffed, you know your call starts 8 a.m. in the morning, and you are in theater that day, and you don't leave theater till maybe 6 or 7, and then you are the doctor on call, but the patient is in the emergency and would already be seen in the emergency. Maybe the patient comes by 8 a.m. where you are not available to see that patient because you are in theater doing some other duties. How do you reconcile this? Would you still be, if the patient chooses to sue because you're the doctor on call, would you be liable, given that the patient has already been seen by another doctor, though the person is not a doctor on call? Thank you.
Thank you very much. We have more hands up. I would like to recognize all the way from Port Harcourt, Dr. Dabota Buhari again. Thank you, ma'am. You have the floor.
Thank you very much, sir, for your lecture. I just have 2 questions to ask. One is, if a patient or patient relative asks for treatment to be stopped, and you know that the patient needs that management, and the patient dies, and the patient now, relatives now sues the doctor. For instance, an unconscious patient on oxygen, and the children now request for the oxygen to be stopped, and even give a written statement in the patient's case file that the oxygen should be stopped, and their mother dies after the oxygen is stopped. And they later go to sue the doctor or the hospital. Do they have anything to prove? Because they can now deny that they were not informed or no explanation was done. They just wrote it down. Then the second one, a patient relative or a patient that refuses instruction from the health worker. A patient is placed on nil per hour but still goes ahead to eat or drink water, and the patient now dies. What defense does the doctor have? Thank you very much, sir.
Thank you very much. Dr. Dabota, you may please lower your hand, ma. Dr. Yarima Godwin.
Yes, sir. Good morning, sir. Thank you for the presentation. Yeah, I just have a little concern pertaining to consent and then patient information and documentation. A scenario like this, you have a patient with a like 4-foot gangrene, and then you have canceled the patient for amputation, and this patient declined. And then you cancel the patient again, and he declined, and he's opting that, oh, if the debridement could be done, which you know that it is not right for the debridement to be done. At this point, what will the patient, will I do, or will the health worker do if this patient remains in the hospital and then is not offered the amputation, which is the right treatment for him at that point? And then his condition deteriorates and he dies, and then the relatives now sue to the doctor. What would be the fate of this doctor? Thank you, sir.
All right, let me
Thank you very much.
Okay.
Yes,
Dr. Yarima.
Yes, sir.
Barrister, we have more comments. Would you like to address them now?
Let me take all of them. Let me take
some questions.
Let me take all of them, sir.
Okay, sir. Okay, sir. Noted, sir. The chat room reads from one of the participants asking, please, is there a way to change the legislature regarding advertising, as many Nigerian patients do not know what the doctors in the country do? Even worse, some doctors do not know what their other colleagues do. So the person is asking about advertising, what can be done. Also, we have Professor Osime, the earlier speaker, is asking if he could get a minute or two, maybe after you've addressed your points, sir. We also have goodwill wishes from Dr. Olatunji Adenekon, is the chairman of the largest NMA in the country, NMA Lagos, consultant ophthalmologist. You're welcome to our midst, sir. Well, thank you very much. Also, there's a request from Iswako Akaniene. Thanking you, sir, for the wonderful presentation. It was enlightening. Yes, the person would want more light to be thrown. I don't know if I'm being heard. Yes, the person wants more light to be thrown on the example of. Yes, the person wants more light to be thrown. On the example of infamous conduct and the name given to doctors colluding with diagnostic centers for a fee. Also, from JP Adu, for patients with special directives, for example, no blood resuscitation or DNR, do not resuscitate, are they not obliged to bring documents that can be made reference to or for record purposes? Can I take such instructions verbally, and will I be liable or not if I ignore such instructions? One more before we take responses from the presenter, Barrister Osanyin. Dr. Ndukwe Ifeanyi, please, you have the floor, sir.
Thank you very much once
Dr.
again.
Ndukwe.
Yeah, thank you very much once again, ARD movie. I also want to join others to say a big congratulations and also to thank the presenter. So my question is, in the area of, for instance, like contraceptives, especially among couples, not individuals, couples, and also the area of the law of the land and also some of the culture, because just as in Nigeria is a very big entity, the culture in the north varies from the culture in the south. The same also, this culture in the east also varies with the culture in the west. So is there the, for instance, for a woman, for a wife, can she go ahead to have a to get a contraceptive without the concept of the husband? And also, what will be the effect of the doctor who goes ahead to administer that contraceptive without both parties having a mutual agreement before presenting for such a procedure, vis-a-vis maybe ligation of the tube? Thank you very much, sir.
All right. Okay, let's answer the questions now.
Yes, sir. Thank you, sir.
I hope you can hear me.
Yes,
right.
sir. After that,
yes.
we'll take a comment from Prof.
Yes.
Thank you, sir.
I'll start from the last question. Contraception. Well, a woman that is an adult that has her mental faculties intact does not need her husband's consent for contraception, and neither should the doctor for it. The only times where we train to ask both parties to be available is when you are having assisted conception, you know, but ordinary contraceptions and things like that, even for transfusion, even the woman can even consent by surgery. So the myth, the misconception that you need the woman's husband to come and consent for transfusion or for operation is Then on the issue of documentation, on the issue of patients who give advance directives, like do not resuscitate, it has to be documented. It cannot be verbal. As a matter of fact, there are even DNR do not resuscitate forms. So there are actually certain forms that the persons must fill. It shouldn't be a verbal discussion. It should be documented adequately. Infamous conduct is with respect to how your behavior while you are working as a health worker. So in essence, it need not be negligence. But it has to be if you have behaved inappropriately in the course of your work as a doctor or as a health worker, as the case may be. So you cannot say infamous conduct if you take it one way. There can be infamous conduct if you use if you use a letterhead of another hospital to treat a patient or to write a referral letter, it can be famous conduct if you write fake death certificate for patients you did not see, and things like that. So that's infamous conduct. It's behavior. It doesn't have to do with negligence. You have not done anything below any standard, but your behavior is unbecoming of somebody who should be in that profession. They want to ask if there is a law that can change legislation on advertisement. It's about time. Unfortunately, the doctors, particularly people in the health sector, use in silos. And it's quite unfortunate that I've seen it over and over again that health workers work in silos, so they are always disjointed approaches to things. I know for a fact that the Code of Medical Ethics was reviewed recently. There was a lot of shared a bit of secrecy as well. It's important. Then again, other areas, other medical bodies try to pass bills. Other parliamentarians also try to pass bills, and you find out that doctors are caught unawares. Health workers are caught unawares. So I believe that first thing that will happen is that the Nigerian Medical Association should actually have a desk at the National Assembly. NMA should have an office at the National Assembly. There's no law that should pass, through the chambers of the National Assembly that relates to health that the NMA should not have at least, in particular in. So that is very important. It's just the same way in which certain government agencies, Federal Consumer Protection Council, so they are trying to regulate medical practice. That matter is in court. I've sued them anyway in that regard on behalf of the doctor. We find it regularly now that various places are coming. But you look at it, the law was passed somehow and nobody observed it when the law was passed. But that question was also intriguing because the person asked if doctors do not know what other doctors do. The law allows you as a health worker to inform your colleagues. That's not termed advertisement. So if you are new in a new locality and you are a specialist or you provide certain services, the law allows you to inform your colleagues. That cannot be advertising. Somebody talked about having a patient who something about amputation and consent. The patient has a right to refuse medical treatment, even if he or she knows that refusal will lead to his or her death. But when you have advised a patient and the patient is refusing your advice against medical advice, I believe the best thing to do is to refer that patient to somewhere else. Or if you believe you can still maintain a patient, you can still do. Something about if you tell a patient kneel by mouth and the patient eats, well, that is at least contributing negligence. So the patient has clearly not followed your instructions. In such an instance, the options are for the doctor either to terminate the relationship or to continue. So if I've had instances like that, but most patients actually don't obey you doctors. They advise patients not to take ice water, not to take cold things. They advise them not to, take salt. So you can't be by virtue of that terminate the relationship. So I believe that it's a normal, unfortunate situation where patients, do not take admonishment of doctors. Somebody talked about the 12-hour and the 4-hour rule, and if he was in theater. If you're in theater, that has already exonerated you because it shows that you are doing something else. Then the concept of triage comes in, really, so you cannot be held liable in such instances. I think I've answered all the questions. Hello, I think I've answered all the questions. Is there even anyone else?
Thank you, sir. Thank you very much, Barrister. Yeah. It's been a pleasure. Your friend, our chairman, NMA Lagos, the largest NMA in the country, would like to say something, sir. Okay. Dr. Adenekon, you have the floor, sir. Thank you, sir. After that, Professor Osime would make his comments. Thank you.
Can you hear me? Am I audible?
Yes, I can hear you, sir.
Yes, you are, sir.
Yeah, thank you very much. I would like to join others in congratulating Dr. Egbekunle, the ARD executive, and the entire membership of resident doctors in Igbobi for this OGM. And to say that I want to appreciate other speakers who have spoken earlier. Barrister La-olu Osanyin, I want to thank you for always being there for us, to listen, to give knowledge to the body of doctors. It is indeed your field, and we know you are very vast in that area. Just to say something that concerning some of your advice, some of them have been taken into consideration for years now. It's not more than 4 years now that we have had a desk at the National Assembly by the NMA. And in recent times, there has been a lot of bills that members will appreciate that we've been flying everywhere. The reason why we got to know about those bills is because we have that desk at the National Assembly. So something positive has come from that. And we remember in 2018 or 2019, it's not the first time you are giving us some of these informations and lectures. Permit me to also state that you will recall that you and I have also been at different fora to be discussing some of these things, and including the issue of advertisement and publicity and all those things. I agree with you perfectly. We are in the era where we should be able to advertise. We should be able to advertise. It goes on. Somebody called me 2 weeks ago. I was telling me that one of our seniors is on billboard in US and all those things. I was asking me this question. I said, yes, that is the notion. That is the what we want to achieve. But as the law is now, as long as the law is now, we cannot advertise. So, like you mentioned, it has to be something you have to go through the assembly. In fact, among ourselves, we are not even convinced that people will allow that to happen. Because this bill that you said that the MCLM Act that has just been reviewed, I can tell you again, nobody touched that advertisement area. It is still left there. So if people feel that it needs to be talked about, we need to start discussing among ourselves. But I can assure you, it's going to be a very, very tough one to be able to pass through. But we need to start talking about it, about advertisement, so that people know the services. And I remember the little discussion we had with the MCLM at that meeting, where we were trying to decipher where does publicity and where did the advertisement end. And I remember this slide vividly, that I've even used it to talk to people, because I captured that slide in my brain ever since I've listened to that lecture. That once it can be traceable to you, that you are doing this for the purpose of, it is advertisement. It is advertisement. Until that law is changed, I'm sure every practitioner must just adhere to what we have on ground now. And I think that is what I needed to put in. Barrister La-olu Osanyin has been working with us in Lagos State with reviewing a lot of laws, telemedicine, what's the other one that we did? Cosmetic practice. We went about to review clinical, specialist clinic, all those things, a lot of things. So he has been very handy to us in Lagos State, and NMA appreciate him. Just to say this. Thank you very much, sir.
Thank you very much, sir. And I'm happy that some of the things we discussed then are being implemented now. I'm happy about the fact that you now have a desk at the National Assembly. I must give you kudos for that. So at least it shows that we are getting traction with our medical legal activism. Thank you so much, sir.
Thank you very much. And I remember in your lecture, you always say that some of these things, you just say people don't use it. People don't come and learn.
Yeah,
I remember you said that. So I needed to point out that we are using them.
Thank you. I'm elated. Thank you. Thank you very much, sir. Thank you.
Thank you very much. That was the chairman of NMA Lagos State. Sir Barrister, I know in law, especially as it concerns Nigeria, advertisement is also not allowed. To the best of my knowledge, I stand to be corrected. So I would say maybe medicine is also trying to cue in from those interests, because big companies would outclass the small companies. If this law comes to Professor Osime would like to make Professor Osime.
Thank you, MC, for recognizing me. Barrister Osanyin, my brother, I want to appreciate you for the very lucid presentation. I truly appreciate you.
Thank you, sir.
Yeah, just a few comments, not really. On the issue of consent that the young man talked about, the consent form, that generic form, is actually not useful. That generic form is not useful. You see a form that tells you the extent of surgery, left to the discretion of the surgeon, and all such things. It must be modified. Each hospital has to set up a committee to have something more detailed. If you see what they will use in both hospitals, like a child's play, you need to see some consent forms, about 2-3 pages, detailed, so that people can really go into detail. The patient must know, like rightly said, what is going to go in for. Even some consent forms, I've seen it there. Possibility of death on the table. Patient will be informed that you can die on the table. It's there in some consent form. So that when the patient accepted that, then you can offer some defense. However, some persons don't understand that clause, leaving the extent of surgery to the discretion of surgeons. It doesn't mean you can become careless or negligent while you're doing that procedure. What it simply means, like I mentioned earlier, is that if, for example, you were doing a CS for a woman already outside children, is bleeding torrentially, it's not stopping, you can remove the uterus to save the life of that person, even though what is signed for at that point was CS. But it was expedient to remove the uterus to conserve the life of that woman. That can be done. That's what it's saying. But you cannot be saying you are doing a CS, you want to remove appendix. They are not connected at all. So people don't understand that extent of surgery depends and left to the discretion of surgeons. So when you put the abdomen, you want to do anything you want to do there, that would be wrong. Now on the issue of DAMA, again, people don't understand that principle. Discharge gets medical advice. If a patient has discharged, like it's not the way people do orthopedic surgery there, you want to fix a bone of a patient, and he says, no, I don't want surgery. That patient didn't say, don't give me pain relief. He didn't say, don't give me tetanus surgery. He didn't say, don't give me antibiotics. You give care within the limits of what's acceptable to the patient or the patient needs. But what I find is that once they discharge his advice, that patient is literally abandoned. That is not acceptable. If a patient says, I don't want surgery to fix this bone, until you reach that facility, you will still check on that patient, check the vital signs and all that, give your antibiotics, give your fluids if he's not eating, and all such things you need to do. Otherwise, if a patient dies of sepsis, you are liable. Because the man didn't say, don't give me antibiotics. You said, I don't want to do open industrial internal fixation. We must be careful about the word, because most people would think they would rely on that document of DAMA. And I tell you, if you don't have a true understanding of the discharge medical advice, that document is a mere paper, and it can disappoint you in the court of law when you say I will rely on the patient side. The process of obtaining that discharge advice, the process is far, far more important than the signature. I thought I should mention those two things. Thank you very much.
Yes, thank you so much, Prof. I do agree with you totally that the consent form we have here is totally inadequate. However, it is in the code. I believe those are the things that we need to reform as well. I think that the authors of that particular consent form were considering the educational disadvantaged status of a lot of Nigerians, because I've seen some consent forms, they look like textbooks. You know, there's a consent form for the surgeon, there's consent form for anesthesiologist, and that, and you know, it gives you full details of likelihood of whatever possibilities that could happen as a result of the treatment. But you know, I believe that in Nigeria, they just give that consent form just to fulfill all righteousness. I believe, and that's why I'm happy that this kind of engagements are happening, and that eventually we'll begin to do the right thing and will be evolving. You know, so I do agree with you totally, sir, that the consent form that we have now it's most inadequate. But unfortunately, I'll advise that practitioners should still stick to this consent form because it is what is prescribed by the Code of Medical Ethics. Thank you so much, Sam. I will send the slide down to the.
Thank you.
I'll mail the slides down so that members can share.
Thank you so much, Barrister. For emphasis, Barrister Osanyin is an internationally renowned medical legal consultant. If you're not very conversant, you might think he's a medical practitioner. Of course he is.
I'm not a medical practitioner. I'm not so that you don't go and give me injection. I'm not a medical practitioner, sir. So.
Yes. Thank you so much, sir. He's currently the first and only African on the board for medical law. It's a pleasure to have you, sir. Thank you so much for sharing your time with us today. I will look forward to further interactions. Thank you, sir.
Thank you. Thank you for having me. I appreciate it.
Yes, sir. You may please stop sharing your screen, sir.
Yes, I will do that right away. Thank you. All right.
Thank you, sir. So, Novartis Pharma, in the next 10 minutes, will quickly just give us their drug presentation. Novartis Pharmaceutical is a household name. They need no introduction. They are here today to give us a presentation. In the next 10 minutes, we're moving fast now to concluding this scientific conference. We thank all our guests here that are present, distinguished ladies and gentlemen, so many big wigs and medical elders here, too numerous to mention, but for whatever reason missed your, please, my apologies on behalf of the president of the ARD. Novartis Pharma, please, are you there? If you're there, please, can you quickly share your screen? You have just 10 minutes. Your time has started, please.
Good morning, everyone. My name is Yuna from Novartis, Nigeria Limited. I would like to stand on existing protocols. I wish to thank the ARD for giving the opportunity to present at this OGM, and I'll quickly, in the next few minutes, discuss about FLOTAP and how it meets your met needs in pain management. As we know, pain is one of the most common sensations experienced by most sufferers, and it can be very traumatic and very unpleasant. And as much as possible, and it can be classified in two ways based on intensity and duration. And in terms of duration, it can be said to be acute or chronic. For the purpose of this presentation, I'll be discussing osteoarthritis, which is a common example of chronic pain. WHO estimates that 25% of adults with 65 years suffer from pain associated with osteoarthritis, and 40% of adults greater than 70 years will suffer from osteoarthritis. And as a result of this, they will have some degree of limitation in movement. And this limitation will basically affect their quality of life. What is arthritis? It is a very common degenerative disease that occurs as a result of wear and tear of tissues at the joints. And for most patients, common symptom is pain. And because of this, they can't go about their daily activities. Imagine not being able to sleep or zip your dresses or even climbing up the stairs. Imagine that Igbo man who built a house in his village and is hoping to retire there someday. And then because of arthritis, he can't climb up the staircase. This can be a really bad concern. Or I buy Jimmy shoes and I can't wear the heels then because of the pain I feel at my knee. So it's very important that this condition or this pain be handled. Currently, in the management of osteoarthritis, you can use the pharmacological approach or pharmacological approach. And the main drug that is what is used majorly is the NSAID. The patients that have arthritis, their major is that they don't get good relief of their pain, and some of them complain of stomach irritation. Out of the population that was surveyed, only 52% of them can comfortably say that they're getting good relief of their pain. So it's very important that an ideal analgesic or analgesic is offered to this patient to address the pain as much as possible. And there are certain factors you need to that when giving this pain. An example, we have to consider the rapidity of actions. One thing, your pain is another thing for that pain to be relieved very quickly. You want a drug that has a short half-life, so as soon as it does work in the body, is eliminated and doesn't accumulate to cause adverse events. It has a prolonged duration of action to last for a long time and cover them for the whole day. It's non-opioid, but the potency is comparable to opioids. And as much as it has less significant side effects. And it's used merely after post-operation, will not interact with the anesthetic that was used for that patient. With this in mind, I like to introduce FLOTAP, which is a novel medication from Novartis. It's been developed to yield clinical results, better clinical results than the other diclofenac combination, which I would like to say that we are the inventors of. We are the inventors of diclofenac. complex with that cholestyramine, which helps reduce mucosal damage with GI. And this formulation actually optimizes the efficacy relationship, which is basically the unmet needs that most osteoarthritis patients experience. So what we're saying is that with FLOTAC, you can get as fast and as quick 20 minutes onset of action, which means that your patient is going to get rapid relief of pain. And not just that the relief is rapid, it will last them for 12 hours because it's been shown to be in the blood plasma even after 12 hours. As I said, the cholestyramine helps to reduce the contact of the drug with the GI. And I see in this slide, when the patient takes the drug, the diclofenac doesn't have direct contact with the GI, but it's only when it gets to the spleen is the site of absorption that it is released. FLOTAC has a biphasic release formula such that as soon as the drug is ingested, 70% of it is released immediately upon absorption, and the remaining 30% of the drug is slowly released over time. So this is also another way the drug helps cover the patient for the whole day. And as for osteoarthritis patients, said it's a disease of the joint. So what it does is that it at the site of the pain, which is the synovial fluid for most patients. And in the blood plasma, where it is not dead, in 1 to 2 hours is relieved. And you can see from the pictures, the knees, the hip, that the drug is actually concentrated there to give your patient very good relief. And if the drug is dosed in the right way, which is to give twice a day for 2 weeks, and then taper it down for once a day, the patient is going to get the best advantage or benefit this drug offers. And how this works is concentrate in the synovial fluid twice a day for 2 weeks, and then you can now reduce it that way. It is also going to be safer for your patient. So depending on the severity of the pain, whether it's mild, moderate, you can give once a day, but if it's very severe, you can do twice a day. But it's not advised that the patient be given the drug a very long time, BG. In summary, it's an optimized patient that helps to balance the efficacy-safety relationship, which means that the patients experience. They complain that they're not getting the relief and the GI irritation. And like I said, it's the coating of the cholestyramine helps to minimize contact with the gastric lumen. And we know that the majority of the ulcers are basically caused as a result of the local contact of the drug with the NSAID. It has a rapid relief of onset of action, so your patient is getting very quick relief of in 20 minutes or less. And this will cover them for a very, very long time. We also say that with FLOTAC, you can combine it with Sidalud, for patients with low back pain. And that the reason for this is because we've seen that combining muscle relaxant with a pain medication, NSAID, for example, will help relieve the muscle spasm, and this will help break the vicious cycle of pain, spasm, pain. So for patients who have osteoarthritis, you can give FLOTAC alone, and while those who have low back pain, you can combine Sidalud with FLOTAC. And like I said, it is very effective for those who have low back pain. It would also give them rapid relief. It's generally well tolerated because Sidalud has some form of GI protection in addition to the protection that FLOTAC has. Like I also mentioned before, it will also intervene in the pain spasm cycle and help relieve the pain for that patient. And in the management of low back pain, you can give patients FLOTAC twice a day for as long as you want to give. And then Sidalud can be given 6 milligrams daily in divided doses, 2 milligrams morning and 4 p.m. at night. I also like to mention quickly other products, Barrister and FLOTAC, which are majorly used for chronic pain. And then for acute pain, we have Cataflam. We also have the suspension of Cataflam for children, which is very effective in relief of their pain and also fevers. Thank you very much for your time, and I hope that your patients will be patient more, that if depending on the kind of pain your patients experience, that you consider our brand for your patients. Thank you.
Thank you very much. That was a beautiful presentation by Novartis Pharmaceuticals, talking about FLOTAC. I'm sure everybody here has heard about FLOTAC before, but it's a good reminder. If we have questions, please, can we please ask by indicating the virtual raise of hand or typing into the chat box. FLOTAC, additionally, is a medication that I know you can give for both genders. Some other brands you have to consider an added agent, misoprostol, but with this one, with cholestyramine, it's usable for both genders. Thank you very much, Pharmacist Yuna. Would there be questions? We'll quickly take them in a minute or two. while we prepare for the next agenda. Next agenda would be a citation for Dr. Jaifa.